Good morning. I'm Gary DeWaal, and this is Bridging the Week for July 29th through August 2nd, and today is August 5th, 2019. Both the Commodity Futures Trading Commission and the Chicago Mercantile Exchange brought and settled charges against the CFTC registered floor broker, claiming he engaged in spoofing trading on the CME. The two regulators' charges largely echoed each other. Separately, the United Kingdom's Financial Conduct Authority finalized guidance setting forth which crypto assets and related activities are likely within its regulatory perimeter. For the next few weeks, I'll be writing and recording Bridging the Week from the base of Rocky Mountain National Park in Estes Park, Colorado. So I can get a few miles of hiking in before I start my daily work. Let's get started. Both the CFTC and the CME brought and settled enforcement actions against Benjamin Cox, a CFTC registered floor broker, claiming he engaged in spoofing trading activity on CME. The CFTC's enforcement proceeding addressed Mr. Cox's purported spoofing conduct from April 2014 through February 2018, while CME's disciplinary action highlighted his alleged spoofing activity for a lesser period of time, June 2017 through February 2018. The CFTC and CME each claimed that during the relevant times, Mr. Cox entered quote-unquote relatively large bids or offers on one side of NASDAQ 100 and E-mini S&P futures markets to encourage trading against smaller orders he placed on the other side of the markets. Both regulators claimed that Mr. Cox placed his larger orders with the intent to terminate them before execution. To resolve the enforcement matters, Mr. Cox agreed to pay the CFTC a fine of $150,000 US and the CME a fine of $50,000 US. He also agreed to a 3-month trading prohibition on all CFTC registered trading facilities and a 3-week access ban on all CME Group trading facilities. In June 2019, the CFTC and the Chicago Board of Trade brought and settled parallel enforcement actions against Eagle Market Makers, Inc. for purportedly engaging in prohibited wash sales on multiple occasions during the pre-open trading periods of various agricultural futures products. Eagle agreed to pay $350,000 US to resolve the CFTC matter and $150,000 US to settle the CBOT matter. At the time at question, the societal benefit of both the CFTC and CBOT bringing parallel enforcement actions where all activity occurred on the CBOT and the CFTC and CBOT charged Eagle with the same offense, wash sales. I raise the same objection here. Is the CFTC so flush with resources that it can bring parallel cases to exchange disciplinary actions regarding activity solely confined to the exchange's trading facility? I think not, but that's just me. I have more on this on the article version of this vlog at www.bridgingtheweek.com. Check it out. The UK Financial Conduct Authority issued final guidance regarding how different type of crypto assets likely fall within its regulatory perimeter and warning that persons conducting regulated activities, for example, business activity involving crypto assets within its regulatory perimeter, typically must be authorized unless exempt. The FCA initially proposed its guidance in January 2019. The FCA's final guidance was issued after it received input from over 65 respondents. Generally, FCA concluded that crypto assets that do not provide rights or obligations typically associated with shares, debt instruments, or electronic money are not within its regulatory reach. These typically include what the FCA terms quote-unquote exchange tokens or virtual currency in many jurisdictions. For example, tokens used as a means of exchange which are not recognized as legal tender. However, certain activities involving exchange tokens will soon be subject to anti-money laundering requirements in the UK. The FCA said that stablecoins, which it regards as a different category of crypto asset as an exchange token, are likely to be either regulated or unregulated depending on what rights or obligations a holder may have associated with ownership of such tokens. Generally, said FCA, there are 4 types of stablecoin: fiat currency-backed, crypto collateral-backed, asset-backed, and algorithmically stabilized. According to FCA, depending on their structure, stablecoins backed by financial assets, physical assets, or other crypto assets might be regulated if a token holder has any rights to the underlying assets or rights to payment or profits derived from the underlying asset. Otherwise, the stablecoin is likely unregulated, although soon such tokens may also be subject to AML requirements in the UK. Finally, the FCA said that crypto assets akin to shares or debt instruments, for example, security tokens, are likely within its regulatory perimeter, while digital tokens that are effectively, quote, electronically stored monetary value, end of quote, are likely subject to the UK's e-money regime. In its guidance, FCA provided many specific and alternative examples of characteristics of different crypto assets and how they might be categorized in its guidance. This is a very helpful document and worth reviewing. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a nice week, and until the next edition of Bridging the Week, ciao.